62 of At Your Service with Haber and Martinez. You may notice that Martinez is not here today. He was unable to join us, but I do have a special guest, Bruce Fleisher, attorney extraordinaire, who I will introduce in a moment. And today's topic is capital punishment and death penalty litigation. Bruce is joining us graciously, and he is a absolute expert on that subject. And we're very lucky and proud to have him join us today. Before we get started, let me just give you a little background. Bruce has been a lawyer since 1973. He's on his 50th year as an attorney, which is pretty incredible on all levels. Certainly doesn't look it, and it doesn't seem it, I'm sure. But Bruce started his career right here in the Miami-Dade County Public Defender's Office. You all may recall a couple weeks ago we had the public defender, Carlos Martinez, on, and we talked about some of the great lawyers that his office has produced, and Exhibit A is to my left, Bruce Fleisher. He left the PD's office and started his own practice, and it's been a sole practitioner since then. He does all sorts of criminal cases and some very complex civil matters as well, both in state and federal court. I wouldn't venture to guess how many hundreds of jury trials Bruce has conducted over his career, but I do know that he has litigated 37 capital cases, meaning death penalty cases, to jury verdict. And that's just, maybe 37 doesn't sound like a big number to you, but when you hear a little more about death penalty litigation in capital cases, it's an astronomical number. And it certainly would put Bruce in the very top of the pyramid in terms of experience for capital litigators. So with that one more thing, I put this in the promo materials, and I'm sure we'll talk about this during the course of the show, but I just want you all to know that Bruce has represented a lot of infamous clients, including, you may know, the individual from The Departed, John Connolly, the Scorsese film that was played by Matt Damon. Bruce represented him. And he also represented an individual named Meese, who was involved in a significant, nasty first-degree murder case, racketeering, and all sorts of other charges here that wound up being a movie as well, Pain and Gain, with, I think, Marky Mark and The Rock. With that said, Bruce, thank you so much for joining today. Really appreciate having you.
Happy to be here. Thank you for having me.
So was I accurate when I said that you probably are in a thimbleful of the percentage of the most experienced capital litigators on earth? Or am I exaggerating?
Well, I think based upon the statistics, I've probably been one of the most active ones in the state of Florida, maybe throughout the United States, in the actual defense of capital cases, in addition to the actual trial of capital cases from start to finish to jury verdict.
What makes a capital case different from any other case?
Capital case means that the state of Florida or the United States government is seeking the death penalty of the defendant. They want to put the defendant to death, and that's what makes them the most difficult, the most challenging, and the most interesting of all criminal cases.
So when you're looking at a capital case, let's just talk about Florida for the moment. Used to be more expansive crimes were punishable by capital penalty here in the state of Florida, but now I think it's only first-degree murder cases. Is that correct?
It's only first-degree murder now.
And but it used to include capital sexual battery, right? Like if you committed these horrific acts on children and stuff like that.
It did many, many years ago.
So in order to be a death-qualified case where the state can actually seek death, it's not just your everyday run-of-the-mill homicide, right? I mean, we've got homicides that occur every day here in the state of Florida, but they're not all capital cases.
No, it's all governed by Florida statute, chapter 921.141, and they designate what they believe. This is pursuant to the Florida Supreme Court and the legislature when it was put into law. They believe that the way that these cases should be decided are on the aggravators and the mitigators. The aggravators are those reasons which the state of Florida or the federal government believes that a defendant should be eligible for death, that the crime was heinous, atrocious, and cruel, that the crime was cold, calculated, and premeditated. And then there's another aggravator, which is very serious, and that is the elimination of a witness, which deals with obstruction of justice. Those are the three ags, as they call them, which the state of Florida or the feds look at when determining whether or not they should seek the death penalty in a criminal prosecution.
And so the folks know, we've talked in the past on other shows, and whether you've seen other shows or not, you may have heard these terms before: aggravating and mitigating factors. I mean, they apply in most people's households every day, and certainly when you're dealing with your kids or your spouse. But aggravating and mitigating factors are not only limited to capital cases. We deal with them in regular criminal cases all the time in terms of sentencing issues, right? So in any given criminal case, if you have to go to a sentencing hearing, the state's going to usually try and find some reason to argue for a more harsh sentence called aggravating factors. And then there's a statute that lists a series of mitigating circumstances that we would use to try and persuade the judge to give our clients a more lax sentence than that which the state seeks. Do those mitigators apply as well to capital cases as they do every other case?
Yes, they do. You're picking up some static, Mike, and I'm not sure if that is being recorded. I don't hear it. That's better.
Yeah, I'll get a little closer. So I was asking if the same mitigating factors that we use in all criminal cases, unsophisticated manner, things along those lines, mental health, need for restitution, do any of those apply in your types of capital cases?
Yeah, they definitely apply to capital cases. First of all, defense lawyers are always looking to resolve a case if possible, whether it's a capital case or just a regular criminal case. And they want to present mitigation about their client, why their client might have committed this crime, how their client grew up. Was the client subjected to sexual abuse, subjected to domestic violence? Does the defendant have a drug problem, an alcohol problem, a problem with prescription drugs? And of course, the mental health, psychiatric and psychological problems that many criminal defendants have. And these are mitigators. And these are mitigators in a capital case that are presented to a jury for their consideration in deciding, do the mitigators outweigh the aggravators? Did this person have such a tortured, childhood, such an abused childhood, or all the experiences that took place in their life, that those experiences molded the defendant into someone who turned out to be not such a good person, based upon all these extraneous purposes. In addition to the fact that some people are born with, brain problems because of forceps delivery. Their mother might have been an alcoholic, and the defendant might have been subjected to or diagnosed with fetal alcohol syndrome. These are all mitigators that are presented to juries if you can't resolve cases. But we try in capital cases to submit death penalty waiver memorandums and document all of this with psychiatrist reports, psychologist reports, medical records, school records, anything that we can show that kind of explains in an intelligent way why the defendant wound up in this position.
Let me work backwards for a minute, because we're kind of inadvertently jumping to the end of the process without talking about the beginning of the process, right? So
yes.
Normally let's start with getting involved in these cases, right? I mean, most people get arrested for a crime and they're bonded out. They're either given pretrial services, they post a bond, or they're even PTA'd or NTA'd in the vast majority of criminal cases. Probably 98% of every arrest here in the state of Florida, people are out one way or another, whether they ever went in or not. And those people either know a lawyer, or they look for a lawyer, or they can't afford a lawyer and they get a public defender. They have to wait for their arraignment for that to happen.
Yes.
But death penalty litigation is a completely different bird, right? Because once somebody gets arrested on a death case, the overwhelming odds are they're never going to see, breathe the free air until that case is resolved.
Well, usually it's even if they're indicted and then arrested for first degree murder, bonds are highly unlikely. Probably in my, 50 years of criminal defense experience, I've only had two or three clients who were released on bond pending trial. But no one ever gets a bond in a state or federal capital case.
So
they remain in custody until there's a plea or until there's a trial.
Let's talk about that for a minute. And again, I want the audience to know this is obviously not a reflection on the attorney. This is just the way the system works. How long would you say, if you can give an estimate as to the average time that a capital defendant, somebody who's accused of a capital crime, who is not able to post bond and is being pretrial detained, how long can they expect to sit here in county waiting for their case to be resolved?
Well, it depends on how much investigation has to be done in the case. There are extensive interviews with the defendant, with the defendant's family. Most of my capital cases encompass having 4, 5, 6 different experts in different areas of expertise dealing with mental health. In addition to the fact that there are some cases, I'm working on one right now where the state's witness list is 130 witnesses. In Florida, we have liberal discovery provisions, so we take the deposition of every witness in a case. No matter how insignificant they are, we take a deposition of those witnesses in every case.
And is that a result of just the nature of this type of crime? So let's say, so the audience knows, you don't only do capital cases, right?
No.
You would handle a domestic violence case for somebody, or a DUI case if you needed to, maybe. Not that I'm locking you into anything, but in those types of cases, would you adopt the same mentality of, I'm going to depose every witness in every circumstance? Or is that unique to...
I do the same in every case. If a client has the ability to pay for depositions, we take them. If they can't, we try to get them declared indigent for costs, because there's so much to learn about a case. And if you don't take extensive depos, I had a domestic violence case that I resolved 2 weeks ago, where the deposition of the victim was 5 hours. The deposition of the victim's mother was 2 hours. In capital cases, I remember we had the baby lollipops case the first time around, which was in the early 90s. We took the deposition of a DCF investigator that took 5 full days. This is why these cases take so long to get to trial. Schedules. Many capital cases have 2 lawyers, maybe 4 lawyers because of co-defendants. So there's the prosecutor's schedule, witnesses' schedule, the defense lawyer's schedule, the court's schedule. We're at the mercy of many different variables that we don't always have control over.
So it's fair to say that these types of cases will last, on the average, you can expect them to last several years.
I'd say the average time to prepare a capital case for trial is a minimum of 3 years, if not 4 or 5. I've had some that last much, much longer because there are problems within the cases, and sometimes clients don't get along with their first attorney, and all of a sudden I take over the case and I have to start from scratch, even though I appreciate what the first lawyer or first lawyers have done. And sometimes people remain in custody 8 and 10 years before that. And then sometimes they have mental health problems where the defendants are declared incompetent to stand trial. They go in and out of competency. I had one case with a lawyer who you absolutely know, Ed O'Donnell, where we worked on the case for 20 years, and he
Wow.
never went to trial. And when he died, my last words to him were, "Robert, you're going to die an innocent man." He happened to kill his surgeon in the office in Aventura Hospital, thinking that the surgeon had done a bad job in a surgery. And we found out that the doctor had done a very good job. We did our due diligence. It's like we researched whether or not he committed malpractice in addition to all the mental health aspects of the case. That took a long time, and every time he would regain competency, he would fall out again. And they had to change his meds, and he had all types of problems within the correctional system, and he had health issues. And his name was Robert Herndon, and he never went to trial, but he was in custody for 20 years.
Wow. And then apart from the duration of these cases, and we'll talk more about the mechanics of what happens during the defense of capital cases, but apart from that, you've got an entire appellate process subsequent. If there's a conviction, aren't there mandatory appeals and just like a never-ending stream of litigation?
Well, it goes like this. If we try a capital case and the defendant gets a death penalty, then there's a direct appeal to the Florida Supreme Court. They are the ultimate arbiter on the initial direct appeal. Then there can be subsequent appeals after that dealing with ineffective assistance of the original lawyers, newly discovered evidence, and some of these cases go on for years and years and years. I'm involved in one that's several resentencings right now, but I'm involved in these cases. Took 20 years to get reversed by the appellate courts.
And these folks are sitting in custody for years waiting to get their jury verdict.
Yes.
And they're in prison waiting for years to get their appeals, right?
That's correct.
Do you do any work, by the way, with groups like the Innocence Project in terms of post-conviction relief?
I have one right now that deals with a foreign national that we've been representing as citizen of a foreign government. And the foreign government is actually paying for the lawyers in this case. And the Innocence Project may come in to work with us on the project. They do a great job, and most of their concentration is on DNA cases.
I've read a couple of studies on the percentages, and it's mind-boggling how many legally and factually innocent people wind up getting convicted. I also read a lot on that they have DNA is their number one, but they also have a lot of issues with eyewitness identification.
Eyewitness identification is a very dangerous area because some people see a crime being committed and they identify a defendant. They don't want to appear to be stupid, so they make an identification. They don't want a defendant to do that again, shall we say, if the witness says, no, I can't identify them, and thinking this particular defendant is going to go out and do this again. And eyewitness identification, they're difficult cases. And that's the beauty of the deposition process in the state of Florida, because we can take a victim's deposition ad nauseum as to everything that deals with the identification of this person, what they were wearing, what they look like, the distance in which they saw what happened. Do they wear glasses? Were they under the influence of intoxicants at the time they witnessed this? I think that it's tough to defend these cases, and you have to show that the eyewitness is not a credible witness, and the jury should not believe that witness's testimony to convict someone of a crime. Now, if there's other evidence, such as DNA or cell phone technology or other forensic evidence, that may help it. But, defense lawyers, they look at a case that just involves eyewitness identification, and that's scary because one person could do that.
I'm always reminded when we talk about eyewitness ID, I always replay the scene from My Cousin Vinny in my mind where he's cross-examining the elderly lady, Constance Riley.
Yes.
And he's talking about her glasses, and he pulls out the tape measure, and it's like a textbook cross-examination in a nice, pleasant way, of showing how somebody could be mistaken.
Well, the first case I tried as a public defender on the 4th floor of the Metro Justice Building, which the old lawyers call it, but it's now called the Richard E. Gerstein Building. It was a robbery case, and the witness identified my client. And I got to cross-examine her, and I said, I want you to look at the clock on the wall and tell me what time it was. There's a clock over the entrance of every double door of the
it's on the far side of the courtroom.
Right. And I said, what time is it? And she said, I don't know. I said, what do you mean you don't know? I said, look at the clock. She says, oh, I can't see that. That was a not guilty verdict. It was my first robbery case.
That's awesome.
Yeah.
So going back to these types of capital cases, I would assume that unlike your average DUI, so, let's say you get, I don't know how many they do a year here in Dade County, maybe 10, 15, 20,000 DUIs. I would say the vast majority of those people are able to pay for a private lawyer. The DUI will vary in price depending upon the skill of the lawyer and depending upon the complexity of the case. It could be $3,000, it could be $30,000. If there's a fatality involved, it could be $300,000. Who knows? But most times they're relatively affordable cases because they don't require a whole lot of time. They do require effort, they do require skill, but your average DUI is not going to take more than 30, 40 hours of a lawyer's life.
You're right.
So it's got a shelf life. Now, these cases where that you're going to be in it, for years, and it's going to literally suck the life out of you, to use a bad pun, I would assume that most people are not able to afford private representation. And so I would assume that the bulk of these cases are court appointed. Have you ever been privately retained on a death case?
I've been privately retained in numerous death cases over the years. And I also would say that the majority of anyone's practice when it comes to capital litigation is appointed by the court, whether it's under the federal CJA or the PCAC that they have in the state of Florida. In addition,
do you know what the breakdown approximately is of your capital caseload, private versus court appointed?
Right now, I have one private one and half a dozen appointed ones.
Okay, so that's probably a pretty good benchmark. So let's talk about the appointment. Well, I guess appointment or not. First, let's talk a little bit about the qualification process, right?
Yes.
Everybody's got a Sixth Amendment right to hire whatever lawyer they want, or frankly, no lawyer at all if they want to proceed pro se. The Sixth Amendment guarantees everybody that right as well. Although, of course, judges have to conduct Feretta hearings to make sure that the individual understands what they're getting into and try and limit the appellate issues.
Yes.
But any lawyer who's got a license can walk into any courtroom if the client is willing to allow it and represent that person on any criminal case, period, paragraph. I don't care if they've never done a criminal case in their life. A real estate lawyer can be hired to go in and try a robbery case. Now, whether they're going to be effective or not is a completely different story. And obviously, if you're a criminal accused of a criminal violation, you ought to hire a skilled and experienced criminal lawyer because that's what we do. the odds that a real estate lawyer is going to effectively handle a criminal case are about as good as the odds of me effectively handling a closing, which are precisely zero. In fact, I wouldn't know a piece of real property if I were standing on it. But that said, death penalty is a different creature. So you're not allowed, I don't believe, or are you? Will the court allow any lawyer to handle a death case, or do you have to meet certain criterion in order to do it? And then part B of that question would be for court-appointed counsel.
You have to have a certain amount of experience in the trial of homicide cases before you are considered to try a capital case. Even privately retained counsel, who could be very fine lawyers, in the area of criminal defense, are sometimes blocked by judges by saying, well, I'm not so sure you're qualified counsel. So we're going to have a hearing to determine all of this, questioning your experience. And then if I allow you, counsel, to try this case privately retained, your client's going to have to execute a waiver. Say, well, I waive my right to challenge or attack my lawyer at a later time because he wasn't effective.
So is that really like the court doing a CYA for its own self so that it doesn't wind up reversed and having to retry a case? Or is that the court really altruistically looking out for the accused?
Well, it is. And remember, death penalty cases are bifurcated. There are two parts. There is the innocence guilt phase, where innocence or guilt is established. And then the second portion of it is the penalty phase. You know, those facts and circumstances as to why a jury should give the death penalty or give life in prison without parole. And you have to know what you're doing as a penalty phase lawyer, or in federal court, it's known as learned counsel, of which I've served probably in 8 federal capital cases as learned counsel, in addition to being lead counsel. And the key to the death penalty litigation is to pick your experts as to the presentation of the mitigation, the testing, the evaluation, the interviewing of your clients. You know, we employ a whole stable full of psychiatrists and psychologists and neuropsychologists and neurologists and people who have expertise in every area that's related to the defendant. There are psychologists who just specialize in trauma, analyzing the trauma that a defendant has had over their life.
Let's hold off on experts for a minute, because
Sure.
I want to stick with just for a moment with hiring counsel and having the right lawyer. And I'm going to share a personal experience that involves you. I was privately retained by a client on a first-degree murder. Well, I was representing the client on a lesser level felony cases when his father got arrested for first-degree premeditated murder,
Yes.
which started as a death penalty case. And the client with whom I had a long-term relationship and a very good professional relationship with wanted me involved in this case. Now, I didn't need a judge to tell me that I wasn't qualified to do a death penalty case because I had never done a death penalty case. I knew this on my own, and I came to you.
Yes.
And I said, Bruce, here's my story. Here's what I have going on. And you hopped on board, and the client decided to retain you. And so you became lead counsel in that case, and I stayed on as a second chair to assist you and selfishly to learn how to do what you do on my end. So not every lawyer is as honest or insightful about their skill level and ability to handle that type of a case.
You're right. And I remember the case very well.
Well, just so you know, as a postscriptum, we wound up severing the defendants all out of the cases, and I went to trial with my client on non-murder charges, whereas you wound up representing the murder client solo and got that case broken down to a manslaughter, as I recall.
Yes,
So that's pretty
with a very
significant
forensic prosecutor.
from a guy who was looking at the death penalty to a guy who will walk out of jail on a manslaughter charge is pretty seriously major accomplishment.
One day he will.
So for lawyers who want to do this type of work, or clients who are looking for lawyers who want to do this kind of job, what are the qualifications that you have to have? Like, let's say I want to get on the wheel and become a court-appointed death penalty lawyer here in the state of Florida. We'll talk federal later. What does the lawyer have to have? Do you know the benchmarks?
It's all in the rules of criminal procedure in Florida, but they at least have to try at least 2 homicide cases. And it's kind of like the chicken or the egg or the catch-22 situation, where you can't become qualified unless you've tried those cases. And you can't get appointed in those cases unless you have the experience.
So if you're a young lawyer or a lawyer doesn't necessarily have to be a young lawyer, a lawyer who doesn't do death cases, really what you need to do is you need to be able to find somebody like you who does these cases and
Yes.
as a second chair, so that we are able to then reach that benchmark of trying to verdict a capital case, although we're not lead counsel.
Yes, and we've done that on a number of occasions, but some of the lawyers have dropped out of that process because they see that it's so involved and so lengthy, and they say, I just can't spend the time learning this craft without getting paid for it. And
so how do most of these guys, I mean, I'm not really up on the death wheel here in Dade County. I used to be a little more involved because I was, pre-COVID, we were all in the courthouse and everybody would sit around, and even pre-COVID, back in the days of the pickle barrel, we'd all hang out in the coffee shop and everybody would talk and, it was very fraternal. But my understanding of the general crew, if we can call it that hub of death penalty lawyers, are all guys like you that have been practicing 30, 40, 50 years.
you're right.
So is there a younger generation coming in? And by the way, of those crew, most of them are former public defenders or former prosecutors right here from Dade County. Is that correct?
Well, you're exactly right. And what has happened in Dade County is because there's so many capital cases that I believe the chief judge at one time spoke to the Florida Supreme Court and said, we don't have enough death qualified lawyers, and we would like permission to add some lawyers to the wheel who aren't death qualified, but since we don't have enough, we want to give them the chance to do this. And there's one particular lawyer who was a prosecutor for about 12 years. I had tried cases against him, and he went into private practice about 4 or 5 years ago, and he's a fine lawyer. And he called me and he says, I just got appointed on 2 homicide cases, and they're seeking the death penalty. I need your help. So I would come on as second chair, and it seems that the Florida Supreme Court has allowed, shall we say, the lowering of the bar of experience in having some of these people pick up cases. And they are very good lawyers. It's just that they don't have the experience in trying death cases. So we're there as the safety net for them.
It goes back to what I said before about, you could have an incredible commercial litigator who could take down the biggest corporations in the planet, but be completely incompetent to handle a DUI case.
Yes.
And we talk about this a lot on the show because we do a lot of reference to medicine. It's the best segue or analogy, I guess, because, you wouldn't go to a podiatrist for a cardiac issue. You could have the greatest podiatrist in the world. You could have the worst case of plantar fasciitis, and this guy could make you walk like you're on clouds. But that doesn't mean he's going to clear an obstruction in one of your arteries.
You're absolutely right.
So we have that here with death cases. So, that crew, I mean, what happens when you have all of these older guys that are kind of either phasing out or, I mean, you have cases, or what happens when you have a case and let's say you decide you want to retire, or you've just had enough, or God forbid there's, some medical reason that you need to slow down your practice. What happens to those cases? They just get handed off to somebody else? I mean,
They're going to go back to the capital wheel, and there's an issue as to whether or not they're going to get a very experienced lawyer or someone who is a very fine lawyer, but without that capital experience. And all capital cases have two attorneys in the state of Florida. First phase lawyer takes care of the innocence guilt phase. Second phase lawyer takes care of the mitigation. But the second phase lawyer should know as much and be as experienced as the first phase lawyer, where they work together on these projects, because a lot of the strategy applies to both phases in the cases.
that makes a great deal of sense. And it also makes sense that you want your team to be on the same page. So you can't have the left hand working against the right.
Right. I've picked up a number of cases because of conflicts and different issues where I look at the file and I say, I don't know what this lawyer was thinking, what direction the lawyer was heading in, that they had the case for 2 or 3 years and didn't do anything. And we wind up reinventing the wheel because it has to be reinvented.
And all the while, the client is sitting in custody.
Yes, exactly.
So let's talk a little bit about that second chair. When you say second chair, are you talking about the difference between penalty phase and guilt phase? Or are you talking about the second chair refer to just a co-counsel to assist either of those lawyers?
Well, second chair counsel is always co-counsel and is involved with all the decisions on first phase issues. I work with a number of lawyers, for the past 25 years, and we discuss every decision that's going to be made in the case, whether it's first phase or second phase. And if you're going to be in a foxhole, you've got to be in that foxhole with someone you trust and respect. And it's a team effort. I just happen to have had so many cases that have gone to trial that lawyers call me all the time for advice, especially for experts. I need this type of expert. Who should I call? And I will say, well, here's the expert I would call. This person can help you. But you need to start reading up on this. Read articles on this. Study your craft.
The lawyer needs to become an expert.
That's right. Now,
so if you
I'm
could
not
tell
an
me,
expert,
sorry. Go ahead.
but I know who the best DNA experts there are to call to help me with this. I remember my first DNA case. I didn't know anything about DNA. The jury was out for 3 days before they convicted our client, and we wound up getting a life sentence. But you need to know everything you can about that subject matter. And it shows, because if you're cross-examining a witness, the jury's looking at you, they're listening to your questions, they're listening to the answers, and they're saying, hey, that lawyer knows about DNA. Did you hear that question he asked? Did you hear how he went after that lab technician from the Miami-Dade Police Department? He made that.
Flashes of Barry Scheck.
Barry Scheck made his bones in the OJ case. He's a
very on DNA.
On DNA, exactly.
So what is I know, again, the similarities between capital litigation and any other criminal litigation are a criminal case is a criminal case. So, they can and do vary. It's not the charge that determines anything. It does determine penalties and fees and stuff like that, but it doesn't necessarily determine stuff. For instance, again, going back to the DUI example, you and I could, God forbid, both get arrested for DUI. And one of us may blow, the other may not. One may be a double refusal, the other may not. One of us may have medical issues, the other may not. We could have aggravating circumstances. One of us may have priors or children in the vehicle, or there may be an accident, or there may be collateral charges, or one of us had a warrant. Who knows? And the point is, every case is different, right? So
Yes.
I would just kind of want to get the spectrum idea of what is the shortest trial phase death case versus the longest trial phase death case that you've had in terms of trial time. Not how long has the case been alive, but the actual jury selection to jury verdict.
I believe that I think the John Connolly case was about 2 months. That started out as a death case, but they had waived the death penalty because the government had offered Stevie Fleming, who was one of the contract murderers, a life in prison sentence to testify against Connolly. And there were other people from the Boston mob who testified as well. But the longest case I've tried was the Hungarian murders, which was Noel Durbal, Danny Lugo, and John Meese.
That was the Pain and Gain trial.
Right. That was a 5-month trial.
So that was
Jury.
the trial itself from jury selection to jury verdict was 5 months.
About 5 months.
And what about the other end of the spectrum, the shortest? Death case.
Well, normally jury selection in a death case will take 2 to 4 weeks.
Now, just so the audience gets a feel, normally in most, like a DV case, it'll be 2 to 4 hours, maybe.
Yeah.
Maybe, if the judge is generous, or a DUI case, maybe 2 to 4 hours. Most criminal cases, jury selection, here in Florida, judges are very liberal as a general rule in giving the lawyers latitude for questioning, but still, they put a time limit on it. You know, they're going to give you 45 minutes, an hour, 2 hours, whatever it is, that's it, per side. And of course, the judge has to take some time to do, judge stuff. But 2 to 4 weeks to pick a jury, I mean, most jury trials don't take 2 to 4 days.
Well, because there's a two-part process in a capital jury selection. The first part is death qualification. What we normally do is we have a questionnaire that we send out to the prospective jury panel. You know, the judge may order 200 to 300 jurors to be available over a period of weeks. And we have to know about their feelings about the death penalty. Some people say, I can never vote for the death penalty because I'm a Catholic and I think it's wrong. Other people would say, oh, I can only believe in the death penalty if it's a first-degree murder. Those people would be excused, okay? You have to have the people in the middle who would say, I'm willing to listen to all the evidence before I make up my mind. So then you've gone through, I don't know how many panels of people. I had one before COVID that jury selection was 2 months until you got enough jurors to say, okay, I can be fair. And then you have the general voir dire dealing with burden of proof, reasonable doubt, and all that. So you have to narrow down these jury pools of 50. It may be down to 4 or 5 people each time. And then all those panels get combined and you do the general voir dire and you pick a jury from the death qualification process.
Now, you have 12 jurors on a capital case and usually a handful of alternates, 3, 4, 5, 6?
Normally four alternates. I've had some with 6 alternates.
Because if the trial is going to be 2 or 3 months, you never know. You have to have enough people there. You don't want to start from scratch.
Well, I remember when we tried the Connolly case, we were in the open, I think it was opening statement after taking a couple of weeks to pick the jury. And I noticed that one of the jurors looked like he was having a heart attack. And I always carry aspirin in my briefcase because of that. And my reaction was to jump up into the jury box, give him a handful of aspirins and say, chew these. 9/11 came and they took him to the hospital. He had had a heart attack.
Wow.
We lost the juror. We lost the juror right there. Somebody gets sick. Someone has a death in the family. Someone has a child care issue. you never know. So you're normally going to have four alternates in a capital case.
So just briefly, and because we're running short on time, and there's so many other things to talk about, but just so the audience gets a feel of the maybe one or two points of significant difference between the federal capital system and the state capital system.
Well, the federal capital system changed everything because the federal capital system went by the case law of Ring versus Arizona that said a jury verdict must be unanimous. 12 people must vote. I'm sorry. If one person, it must be totally unanimous. If one person doesn't want to vote for life, doesn't want to vote for death, that person gets a life sentence. Florida, it used to be 6 people had to vote, 6 or more had to vote for death. If they didn't, that became a life sentence. Now the legislature under Governor DeSantis is moving to change all that.
But that's subsequent to the Parkland,
Yes,
correct?
Parkland had a lot to do with that.
So, and can you just tell the folks real quick the why of that? Or the what of that, actually?
Well, I think that if you watch the Parkland case, and I know experts who were involved in it from both sides, defense and prosecution, you'd say that, my God, if he killed 17 people and wounded an equal amount of people, that guy should get the death penalty. But the defense brought forth a lot of mitigation that convinced 3 people that he should not get the death penalty. And therefore, it was a life verdict. If, under Ring versus Arizona, then there was Hurst versus Florida, and Hurst had to reverse any conviction, any death sentence of anyone who didn't have a majority rule. The Florida law changed. The government in Florida wants to change it back to the old way that it was because they don't want it to be unanimous. They want it to be, it sounds to me like 8 people have to vote for death in order for death to stick, shall we say. And the new law is coming out very soon.
Can the judge overrule a jury verdict?
A judge can overrule a jury verdict. And I had one that I tried about 8 years ago in front of Judge Dennis Murphy, where the jury came back 8-4 for death, which really surprised me. But post-trial motions, I convinced him that he should override, and he overrode the jury verdict and gave the defendant life without parole.
And just so the audience knows, you can look back on our old shows. Judge Murphy was a guest on one of our shows about 1.5 years ago. It was very kind of him to come on and share his experiences with us. He was a wonderful judge. He is a wonderful human being.
He is a great judge.
And he was a really, really, really wonderful judge. So a guy that you could really count on. Let's go back to experts for a moment. We use experts all the time in every criminal case. I mean, not every criminal case, but routinely we use them. And the most common example might be a private investigator. Now, I'm going to go out on a limb and say that when I hire my private investigator in my average DUI or domestic violence case, it's probably going to be a different task than when you hire a private investigator in a death case.
Well, we get 2. We have one for innocence guilt phase and one for penalty phase. We also have a mitigation expert, someone with credentials in psychology or sociology that knows how to deal with people and their mental health problems.
Would that person, that mitigation expert, would be kind of like a mitigation coordinator for you? Because you're not going to just use that one person, right?
Oh, no, that would be our go-to person to coordinate what has to be done. And those
just in identifying the other experts that you're going to want in this case.
Yes.
And then so that person would become a hub for information and assistance to you. Would that be a correct assessment?
Yes, that's a correct assessment. Some of the mitigation experts that I use are actually attorneys that don't do the actual litigation. And some of them, I have one now who has a PhD in psychology.
A lawyer, doctor?
Yeah, she's a PhD in psychology, like your mother.
But you would not use that person, would not be a witness that takes the stand and testifies in the case.
Mitigation experts rarely testify
In penalty phase.
In penalty phase, yes. They're the coordinators. They're the diggers. They're the
you do have experts that testify, obviously.
We have normally a forensic psychologist. We have a neuropsychologist who studies the brain and cognitive issues to see if, what this person's IQ is, to see if they have any mental defects. Is there anything wrong with the brain?
Traumatic brain injury, birth-related, whatever.
TBI, traumatic brain injury, yes. And then we will have a neurologist, and the neurologist will examine the defendant and may order some scans if the neurologist believes, there's something here. I just can't put my finger on it, but we're going to do the testing. One of the first death cases I tried, I represented a young kid who was a boxer in Puerto Rico, and he was charged with killing a police officer during a bank robbery. And we did the research and we did the investigation, and our neurologist examined him, and we had a CAT scan, and the CAT scan was read by a very radiologist in Baptist Hospital, and he said he has a brain injury. He has what's known as a cavern septae in the frontal lobe. And I said, "Doctor, have you done this before?" He says, "Well, I diagnosed Muhammad Ali, and your client's a boxer, so I think I can testify to that."
I'd say that's probably the type of thing you want your jury to hear.
That's right. And you bring out your model of the brain and show them exactly what it is.
You talked a little earlier about waiver of the death penalty. That came up. We weren't really discussing it, but you threw that term out, and I wanted to hit that for a moment because what we're talking about now is mitigation, right? And specifically, we're talking about penalty phase mitigation. We're assuming now that the individual is either pled guilty or was found guilty, and you're going straight to sentencing. Like that's what happened with the Parkland shooter, right? He didn't have a trial. He waived his trial.
They made the smart move to not go through.
He went directly to sentencing. So now, when the case is fresh, when it comes into the system, you want to try and secure, if possible, a waiver of death as quickly as you can, so you don't ever have to get to that penalty phase in terms of death versus life. There's a sentencing hearing, but that's very different than a penalty phase hearing, correct?
Yes, we do our investigation, and based upon the investigation of the case and the client's background, we draft death penalty waiver memorandums as to why the death penalty is not appropriate and should be waived in the case, and it's supplemented with records and reports and evaluations from doctors, school records, anything we can lay our hands on that will establish and corroborate what we say and why we say it. And then it's up to the death penalty committee from the state attorney's office.
That's where I wanted to go next. What is the death penalty committee?
It's a group of senior prosecutors who review these things to determine whether or not there should be a waiver.
So I would assume that it's fair to say that just like it's a very small percentage of the defense bar that is competent to practice in your arena to do death cases, similarly, there is a very small percentage of assistant state attorneys who are competent to prosecute death cases.
You're correct.
And I would assume that most of those are very senior trial lawyers.
You're correct, and or they've now become administrators, and they're not trying cases anymore.
So people who used to try cases and stay on in the office just to serve in this capacity or partially to serve in this capacity.
Exactly.
So I think one of the really interesting things about death penalty litigation is the wrapping your brain around the concept, because almost every across the board when it comes to criminal cases, what a client wants to hear, what the family wants to hear is, you're going to walk this guy out of the courtroom, right? Anything else is really not a victory from a base level. Now, we know as lawyers, sometimes depending upon the charges and the criminal history, walking away with probation or walking away with county time is a victory. And so I use that as a preface to what I think is interesting in death penalty litigation, that when somebody gets life in prison without the possibility of parole, that's actually a win.
It can be a win in many different cases. And then we had one particular defendant who was sentenced to death before I was ever on the case with my then partner, now Judge Riumberto Diaz, where we were asked to retry, I think, 5 death penalty cases of one defendant. And over a period of 12 years, we tried all the cases. And he was acquitted on 3. He was convicted on the 4th. It was reversed in appeal. We tried it again. He was found not guilty. And then he was convicted on the last case. The case was reversed on appeal. And then there was one left, and the state attorney just threw up her hands and said, "I've had enough of you guys." And our client pled to credit time served of 23 years. He was on death row.
Wow, that is just incredible.
And
Any other interesting war story that you might want to share with the audience in our final couple of minutes? I know we didn't really talk too much about Pain and Gain or The Departed. We touched on them a little bit, but maybe, something else that really stands out. I mean, again, 50 years is just, many people don't live to 50, much less have a career that exceeds 50 years. So you've seen and done more than most lawyers will ever know in their lifetime.
I think the plus at times, and this one particular defendant, his name was Rolando Garcia. He was in custody for 23 years. And Riumberto and I got him out. And he calls me every Christmas Eve to tell me, "Thank you, thank you, thank you. You saved my life." I've gotten a few other people off of death row. And that is a great feeling. The feeling lasts for a couple of days and then it goes away because you just go back into your work again. But I've recently was asked to take on the defense of Adrian Dorbal, who was the second lead defendant in the Hungarian murders. And I had represented the CPA in that original case in 1998 in that 5-month trial. And my client was acquitted of the murders. My original client, John Meese, was acquitted of the original murders, but he was convicted of lesser crimes involving the money laundering. And he died on appeal. I thought he had a terrific appeal, but he died on appeal.
In custody?
In custody. But when Hearst versus Florida came about and Dorbal's conviction or his death sentence was reversed along with Lugo's and other people, he was represented by other people who have been appointed to represent him in the resentencing. And one of them developed a conflict because of a health issue, and one had another issue. And Dorbal went to that mitigation expert and said, "Could you get Bruce Fleisher to represent me? I know him from the first trial when he represented John Meese." And I was asked to take the case, and there are some waivers of conflicts because I didn't think there were any conflicts. And I'm now back in the mix of that case again.
Well, I would guess whatever conflict might have existed, unfortunately, passed with Mr. Meese.
Well, he died, yes, and they were in 2 different categories, shall we say, when it came to the evidence.
Right. Well, Dorbal was an actual principal to the physical participant in the homicide, whereas
he
Meese was
one of the killers, and he was one of the guys who was very good with the chainsaw and dismembering them.
And I had a little involvement in that case in the beginning, right before the arrest.
I remember that.
That's another story for another time.
I remember
Bruce,
that.
I can't thank you enough. It's been just a fascinating conversation. I'm very fortunate to have known you both personally and professionally for 30 some odd years. So I've heard many of your war stories, and it never ceases to just amaze me about what you do and how you do it. I mean, honestly, my hat's off to you. I could never do that, not because I have an issue with the death penalty, but because I have an issue with commitment. I could never give somebody, 23 years of representation. It's just not possible. Thank you for.
As they say in The Godfather, Mike, this is the life we've chosen. And I started out as a public defender, although I interned in the district attorney's office in Houston, where I went to law school. And I just gravitated toward criminal law, and that's what I know, and I like it. And it's a tough profession, but I like it and I'm good at it. And I like all the people involved in it. The courthouse is our home. We're there all the time. And our DNA is on the floor and on the seats in courtroom 4-1 and other courtrooms where we tried cases. It's hard, but as some of the clients say, you're a real lawyer. You're a real lawyer, Mr. Bruce, and thank you for helping.
Or as they call you at Tropical Chinese, Bruce Lee.
Bruce Lee. That's right. I'm ready.
Thank you again very much for being here today and for sharing your time and your expertise with the audience. I appreciate it. I'm sure that they do too. God forbid anybody should ever need your services. Your contact information has been scrolling on the bottom of the screen. I always say that about myself too. I'm the type of lawyer that you want to have me in your speed dial, but you never want to have to press that button.
That's right. Well, I appreciate being here. I've enjoyed it, and let's go out for dim sum.
Sounds like a great plan. Be good, my friend. Thank you very much for the audience for paying attention to At Your Service number 62 with Bruce Fleisher. Next week we have number 63. We have another guest coming on to join us. And the following week, I will be in trial, so we're taking a quick hiatus.
Okay.
Again, Bruce, we'll be in touch, and take care.
I appreciate it.